officially start. I hand it to you.
Okay, thank you. Well, first of all, I'd like to thank Fordham University Faculty of Law for this invitation. And my name is Massimo Zizzari. I come from Rome, Italy, and I took my degree in law in Italy, and then I studied international law in US, precisely in Texas. I am a Supreme Court lawyer, and I work in my own law firm based in Rome downtown. I practice mostly intellectual property law and commercial law, bankruptcy law, and international arbitration. Recently, I've consulted the Italian Parliament about a reform of trademark regulation in Europe. And finally, I lecture in public law at the Second University of Rome. This presentation will be about investment arbitration as a core issue of our research and developing within the larger topic of international arbitration. I will talk about the fundamentals of international investment law, and at the end I'll analyze some movements regarding the future of investment arbitration. International investment law is a relatively new discipline that has strongly developed in the last 10 years. While the international laws that regulate cross-border investment have existed for hundreds of years, the international investment law was considered at the beginning only as a specific part within public international law. It's only in recent times that young international investment law has been recognized as an autonomous discipline in its own right. In recent decades, the sensible achievements of investment arbitration has allowed international investment law to create its own category of academics, specialized lawyers, and legal doctrine. And international investment law integrated all the regulations that covered a specific economic transaction where the states interacted. But all those regulations had to be considered as a specific application of the traditional general laws among the states. The remarkable growth of cross-border operations that developed during the last century opened the way to a new specific works in international investment law that mirrored the customary approach of defining international investment law, a mere application of a larger doctrine of public international law. An essential turning point happened with the use of investment arbitration as a primary tool to be used in cross-border investment litigation. In 1966, the creation of the Convention of Settlement of Investment Disputes between states and nationals of other states, the so-called ICSID Convention, gathered all the different calls for the creation of an investment state arbitration procedure that became a qualified instrument to solve cross-border investment disputes. However, it's been very rare to face this kind of proceedings before the 1990s, despite of a large international support to the community of investor-state arbitrations. So this, together with the appointment of arbitrators coming from public international law sector, implies that at the beginning, arbitration didn't have a significant impact on the growth of international investment law. Beyond 1990s, on the other hand, there's been a considerable number of cross-border investment disputes resolved using investor-state arbitration. Arbitration tribunals are not affected by the stare decisis principle that drives, as we know, common law jurisdictions. It means that the final outcome, the award, the interpretation of the law within the law, is not binding for other tribunals. And in this way, private investors in arbitral proceedings cannot lead the creation of a law that can affect the ontology of generally investment law. So this new scenario changed even the way of conceiving the methods of law practicing. The population of lawyers, arbitrators, and academics began to set the attention to the progress of international investment law itself, considering the public international law as another doctrine applicable only in case it's allowed by international investment law. I said that this new branch of law had a start based on its practical nature, and it can be considered as an advantage, but it can be even seen as a lack of theoretical foundation. A new field of law, after all, by definition, just can't invoke the same theoretical grounds that were used to validate the field from which he detached. In fact, all the new fields of study claim for independence from a larger subject that requires to be easily noticeable. And in addition, while international investment law will see a community of practitioners building up its theoretical groundings, all these are working will be affected by the fact that at the beginning the detachment cannot be sharp, and that the whole setting is very fast changing and absolutely uncertain. The outcome is that every operator, every arbitrator, every lawyer or academic, as a matter of fact, prefers to talk about the future, the iure condendo, rather than commenting the current situation. And the actual scenario of international investment law is basically this. Additionally, the initial absence of progress in international investment law at the time of its creation, as we said, was related to the fact that there was a lack of theoretical distinction from public international law and its own practical nature. Consequently, international investment law started to move its first steps in anticipation to any relevant doctrine that could confer a certain level of consistency. For all this motivation, the research I'm developing, even if driven by a dominant doctrine, will not come to a definitely conceived conclusion about the nature of international investment law. We still haven't come to a time where it's possible to work sharply on legal definitions, due to the fact that the scenario is still too embryonic and changeable. Consequently, even if the subject is largely supported by the efforts of an international community, those efforts must be considered as a temporary analysis. The basic idea of my research is that 1966 ICSID Convention plays a key role in current substantial international investment law, even if it doesn't include any referral to substantive law. The ICSID Convention is a way to upgrade international investment law to a sort of what I can call international constitutionalism. And anyway, even if constitutionalism conventionally refers to institutes belonging to substantive law, ICSID Convention specifically regards regulations belonging to procedural law, but doesn't tell anything about which substantive rules the tribunals have to apply within the case. And we don't forget that the convention is ontologically nothing but a treaty between states regulated by public international law, and it has never been considered as a first step to potentially introduce in the future a dispute resolution instrument for spotting the substantive regulation belonging to public international law to apply. On the contrary, the ICSID Convention was introduced to face the failure of public international law to create a concrete working setting for international investment law. And by refusing to regulate substantive law, ICSID Convention has denied to acknowledge the existence of a unique regime of substantive international investment law, endorsing instead a system that I will define a system of limited anarchy. As it's generally accredited, public international law has a strong anarchic structure based on the absence of a legislative body and on the lack of a governative organization that is able to enforce existing laws. And in contrast with this authentic anarchy, the limited anarchy referred to international investment law is the result of a combination between international arbitration and international investment law. And this merger has created a legal scenario that implies enforceable restrictions to the freedom of the states to act in whatever they judge to be suitable. And naturally, the consent plays a major role in the application of those boundaries, as investment arbitration is performed only when both the investor and the state agree to go through the procedure. And however, with the growing importance of international business transactions, the investor-state arbitration moved from being just a potential alternative for the resolution of international investment disputes to be the conventional dispute resolution mechanism for this specific matter. So it came the foundation of an institution, the ICSID Tribunal, where the jurisprudential activity has a central role about the way investment law is developed. And the crucial distinction between the authentic anarchy of public international law then and the limited anarchy belonging to international investment law is the joining, at the end of the day, of an ad hoc procedure, pre-designed procedural structure, and a substantive anarchy that exists within the boundaries set by that structure. And the procedural structure of international investment law has been implemented considering the substantive anarchy that it carries. As we said, the ICSID Convention did not just offer the investors and state an instrument for the resolution of international investment disputes. It also mirrored a certain attitude about how international investment should be regulated at substantive level. And international arbitration was considered to be the most suitable mechanism for the resolution of international investment disputes, because it was clear that there was too much diversity among the states on the substantive rules applicable to foreign investment for any regime of universally binding substantive law to be adopted. And however, the adoption of international arbitration as a dispute resolution mechanism created a procedural structure that delivered effective enforcement but avoided the development of any binding substantive law at universal level. And international arbitration then combines substantive anarchy and procedural enforceability in a way no other dispute resolution mechanism could ever do. And what matters for the present purposes is not the fact that international investment law has a two layers configuration, but the impact of that configuration on the content of international investment law. The collective relations among individuals accomplish an essential importance in any anarchic system, because the lack of any collective legal institution means that only intentional acknowledgement of social obligations can produce binding legal regulations. And so, this social approach to the generation of legal rules can be observed clearly in the traditional anarchic system of public international law, in which universally binding rules only develop through the recognition by states that certain conducts are mandatory. So, when an anarchy is limited, however, the importance of these socially derived rules is affected by the importance of the structure within those rules are allowed to develop. The constraining structure of the system, the ICSID tribunal, both creates limit to the substantive rules that the participants are allowed to develop, and influences the interpretation that any rules developed must be given. The research I am carrying will involve issues of substantive law and will try to point out particular emphasis on arguments related to the procedure and other structures within which the law exists. These issues can't always be resolved by appealing to the structures and does not attempt to provide a purely structure-focused analysis. However, ignoring issues of structure in a legal system designed to operate as a limited anarchy results only in conclusions that are fundamentally unfaithful to the law and unfair to those who must act within it. In short, the research is not intended to deliver a fully realized theory of international investment law, and is also not intended to address every major area of conflict within investment law. It is instead an exploration of particular approach to the analysis of problems within international investment law, undertaken through the close examination of certain specific topic. The goal is just to demonstrate the usefulness of structural reasoning within international investment law, and it is, however, indicative of a much more ambitious project, of which this research merely forms the first step. And now, after the general part, let's get to the other topic of my research. It's going to be about the future of investment arbitration. And I hope I will be able to share with you some new ideas that could be useful. Discussions about arbitrators might be a good place to start, because one of the issues surrounding the debate of the crisis about the legitimacy of investor-state arbitration has to do with what arbitrators have or have not done. I had arbitrators respond and say, will states need to be more clear about what they want? So we will follow the necessity to tell the European Union states that they need to have clarity in their treaties. What I'm going to do is an analysis of where we are today in terms of the movement to reform investor-state dispute settlement. I will not speak very much about the ICDS proposal for a new investment court at the UNCITRAL, because I believe it's too early to form a complete judgment, as long as the procedure is too embryonic. I will start by discussing a little bit of background, where we're coming from, what's happened, and what the complaints have been. So, just briefly to go over some of this, you have to start with a goal. What the common theory has always been about is the goal to investment treaties. One of the things I always say to the audience is that investment arbitration is not a right. It's not a right under United Nations Convention, and it is not a right in most constitutions. It's just a grant of sovereign immunity from the state. The states granted this sort of waiver of sovereign immunity because they thought that they were gaining something for it. And it was supposed to lead to great economic development which will be so beneficial that it was worth taking the risk. Some of the concerns are that investment arbitration is too commercial, and it's been modeled on commercial arbitration because that was the model that existed. Other concerns have to do with the fact that the parties themselves appoint arbitrators. And in a number of cases, we have seen arbitrators appointed by a claimant's attorney, different time in different cases. So, how can you really think an arbitrator can be impartial when he's been appointed by a certain attorney who may appoint him later? And then double adding. Double adding is another big issue. This is acting as counsel and as well arbitrator. There's some concern that the counsel part of the arbitrator may influence the determination when that lawyer sits as an arbitrator. And this is something that is much debated, and states have come to the conclusion that in the reform movement they really don't want to see it anymore. Other issues have to do with the effects of these arbitral awards on a state's right to regulate in their interests of public welfare. A number of findings of indirect expropriation force states to change the way they may legislate the environment, health, or public safety. And in addition to that, there are issues concerning the fact that there's no appeal. If you're going to try to annul an award to sender, it's extremely difficult. And essentially you manifest a kind of disregard for the law, whatever law it is. And a standard really amounts to, can you prove that there was corruption by the arbitrator? And therefore it's extremely difficult to get annulments. They happen, but they are extremely rare. And then lack of transparency. And this has been particularly complaint expressed by civil society organizations that these arbitrations are often carried out behind closed doors. And this particular complaint has been respected because a number of seats have allowed proceedings to be viewed, to be live streamed, and so a lot of people can see that there's not people behind closed doors colluding. And if you're dealing with a state's environmental regulation, for example, or if you're simply dealing with an issue that could potentially cost the states hundreds of millions or even billions of dollars, those funds will not be there for some of their activity within the states. And so the issue of transparency is one that has been front and center. Another concern related to the others is the lack of consistency in the award. For example, if you're dealing with the same treaty, there's always so many differences related to the facts of a case that can come, and we had it For instance, in the situation of Argentina, or in particular in Venezuela. These are states that had a huge amount of cases. And nowadays we see it with Spain in the Energy Charter Treaty, where the differing interpretation of legal provisions, not so much the facts, obviously has caused a deep concern. That's because an arbitral award is supposed to be particular to the parties, and this again as a commercial arbitration principle. And however, when you have states that are having awards again and again, you have awards that determine the provision of a treaty, what provisions really mean, or what other agreements mean. And so basically you are establishing jurisprudence. And now we see awards that all quote what other tribunals have said, even if frankly, technically, they don't have to. So let's look at what's happening under the reform side of things. One of the most surprising new model of bilateral investment treaty is the Dutch model bid that was released last year. The past Netherlands bids have often been used by investors through a Dutch vehicle company because Netherlands wanted entities to feel free to cooperate in the country. So this is certainly a turning point in order to balance the rights of the investors and the states, whereas many have felt the treaties were balanced against states. So the new Dutch model bid requires that investors have a substantial business activity in Holland. And so Holland was known for having the so-called mailbox companies that you can incorporate with a pro forma and you obtain rights under Dutch law, including the ability to use their bids. And it was certainly a part of a particularly skillful strategy by lawyers. It would have been a smart thing to plan to have clients in a jurisdiction where they would acquire rights that they don't have under their own system. So one of the other things to address is that the Secretary General of ICSID will be authorized to appoint all the arbitrators. I believe under the Dutch system they would establish a list, but there are a lot of debates running about how the list will be composed. But at the end of the day, it will no longer be the parties designating their particular arbitrators. And even in this case, there will be no double heading again. And as you can see, there's even transparency provisions. Even the United States in the 2000s, after dealing with a lot of criticism of the NAFTA, the North American Free Trade Agreement, this set up a lot of these provisions in its free trade agreements. And included in this is something that more recently has to do with third-party funding. The third-party funding is very much a part of investment arbitration today. There's a debate over whether or not it will increase the number of investment cases. I don't see how it won't. And if you are a finance institution and you're finding something to make money on, then you're going on to do that. Financial institutions can always be trusted to finance the great ventures, and I think it will lead to more and more arbitrations. Now, moving on to CETA, the Comprehensive Economic of Trade Agreement is not a national or bilateral level, but it is at regional level between Canada and European Union, and it establishes a permanent tribunal to hear investment disputes. And again, even here, no double heading. This will be something in the future particularly troubling for lawyers, because it cuts off the resource of work. But I think that this is the way it's going to be. And also important are the substantive provisions. Again, we see the policy to not allow mailbox companies, and the requirements that you have the substantial business activity in the territory of a party has been much discussed. And the Dutch were not the only ones to have this kind of provisions. Luxembourg also was a source of much movement by investors in a lot of cases that have come out in Luxembourg that have nothing to do with companies originated and founded in Luxembourg. And then we get to the issues regarding fair and equitable treatment, the so-called FET, and full protection of security. There's definitely efforts by lawyers to persuade tribunals to broaden the scope of the full protection and security provisions in order to include legal and economic security beyond customary international law. And the idea is that the police in a foreign country should not stand by and see your factory burning down. I mean, they should do something about it. And eventually we saw a movement to try to change the meaning of that. Here, no most favored nation for dispute settlement. The most favored nation is a status accorded by one state to another. And it means the country which has this status must receive equal trade advantages by the country granting such treatment. And trade advantages include low tariffs or high import quotas. And using MFN status, parties since the Mafasini versus Argentina case used to bring in more favorable dispute settlement provisions, and the CEDA prevents this strategic tool. And moving on to some procedures, we see from the European Union the need to limit frivolous claims. And we see also a movement to set up an appellate body, or to satisfy the complaints does not review. So these have to be read in the content of the efforts in UNCITRAL to take on the idea of the construction of an investment court. Looking at the CPTPP, the so-called Comprehensive and Progressive Agreement for Trans-Pacific Partnership, this is essentially a US space model coming out of the US provisions of the 2000s. What we see in terms of substantive provision are limitations in indirect expropriation in order to protect the state stability to regulate certain sectors. And obviously, fair and trade agreement has been also in indirect expropriation developed as a vehicle to attack, for example, environmental regulation, health regulation, and others that are supposed to be in a public interest. One of the other things that we see is the effort to allow states to counterclaim. In situations where you are dealing with a contract that has been alleged to be breached, states are normally unable to counterclaim. And so we see in CPTPP provisions that would allow to counterclaim for the first time. And again, we see corporate social responsibility provisions. And moving on again to the idea of having proceedings that are viewed by the public as being fair, there are provisions which are standard in treaties, in free trade agreements the US has entered into. In the 2000s, we see transparency provisions allowing parties to participate and dismiss the frivolous claims. But you will see there are no provisions allowing for a separate court. A part of that comes from the United States unhappiness with the World Trade Organization. Part of the US reluctance to deal with some of these issues stands on the fact that they really refuse the idea of WTO to be the model to be used, even for the appellate body. Anyway, until the US withdrawal from the TPP, the Trans-Pacific Partnership, the provision for the creation of an appellate body had been in US agreements for about 12 years or so. So, where is the US going? It's by now basically totally unclear. and the situation is very much driven by politics, by international politics. So nowadays we have the US withdrawal from TPP, and then we have the USMCA, the United States-Mexico-Canada Agreement, which is aimed to replace the NAFTA. And for 3 years after the agreement goes into effect, and we have no idea when it will happen, Canadian investors are able to sue under the old NAFTA. After then, there will be no Canada-US investor-state arbitration. For Mexican claims, we are moving into another system that I will call normal claims. Normal claims will be allowing Mexican Union and US investors to sue, but only for national treatments, MFN, and direct expropriation. And otherwise, they will get what essentially is the TPP or the CPTPP. And then there are special claims that I call investors' full rights. And these are investors who participated in the expansion of oil and gas sector, power generation, telecom, infrastructure and transportation, especially during the last Mexican administration. And then about ICSID rules revision, the one interesting thing was that he had proposed to provide time. Some of the provisions regarding transparency that ICSID have proposed were actually refused by the states. And the rules that were released last February, they got rid of the provisions to allow for more transparency. So, said, this is actually what the states wanted. And now, in the given time, I would like to talk briefly about the quantification of damages in international arbitration, investment arbitration, sorry. The growth of investor-state disputes over the past 20 years has produced a large body of case law involving complex and legal and financial issues. At the heart of these cases are multi-million-dollar claims, and these high-profile disputes have created discussions about the principles and methodologies applicable to damages claim under investment law, and understanding damages and valuation issues in international investment arbitration is absolutely important for counsels, for claimants, for respondents, for the experts, and even for the arbitrators. Lawyers must be practical with financial concepts and methodologies to engage with evaluation experts. Will-be claimants need to know the likely amounts recoverable through investment arbitration, and on the other hand, states must know the level or their financial exposure. And experts, meanwhile, must ensure that their damage models are consistent with legal principles on damages. And arbitrators are compelled to make judgments on complicated damages claims and to shield their awards against possible challenges. My research seeks to identify the main questions confusing tribunals through a collection of emerging issues on the law of damages and valuation in international investment arbitration. The valuation is perhaps the topic within the subject of damages in investment arbitration that has seen the most remarkable growth. And now we'll examine some specific cases related to the damage quantification in recent cases in the photovoltaic industry. It's 5 cases in chronological order: ISA versus Spain, Nova Energia versus Spain, Masdar versus Spain, with the dissenting opinion of the arbitrator appointed by the state, and Antin versus Spain, and Green Tech case versus Italy. Indeed, the arbitration panels in all of these cases have adopted a converging approach to damage quantification, which is good news relatively to the criticism made to the unpredictability of the results. So let's discuss damage quantification, and let's discuss about the applicable standards. There's absolutely no discussion about the fact that the standard is the standard of full reparation. It's been consistently acknowledged that the Energy Charter Treaty does not contain a definition of full reparation standard, and therefore this has to be determined on the basis of the international principles of customary law. And in particular, 2 of these 5 awards have referred expressly to the same sources: the ISA award and the Nova Energia award. And not surprisingly, there's been ample reference to the standard and to Articles 31 and 32 of the draft Articles of Responsibility of States for Internationally Wrongful Acts of the United Nations. And all the mentioned arbitral tribunals concurred that the restitution in kind is not appropriate in these cases. So, what would restitution in kind mean in our case? In our case, it will mean to compel the state to change its regulatory framework in order to slow down the legislative changes. And this, of course, will be a huge burden on the states and would be place an improper restraint to the rights to regulate to the states. So instead, the balance has been reached in the mentioned cases, stating that money for recompensation should apply. So, on one hand, the right to regulate of the states is preserved, and on the other hand, the investors that are unduly prejudiced by the legislative measures of the states meet a full reparation. So, the arbitral tribunals indeed have established that the states have a duty to repair in full the damage caused by the breach of the fair and equitable treaty standards under the Article 10.1 of the Energy Charter Treaty. This means that the investors should be placed in the same position that it will have had back before the state's breach. And the reparation shall include both the loss which has already occurred as well as the future foreseeable losses. So again, it's just a repetition of the general principles, with the exception that there's been no discussion here on the principle that the future losses of profits also are contained in the notion of full reparation. So there will be much to say about this topic, but I'll stop here, and if there are any questions, I'll be here for you. Okay.
We only have a couple minutes, but if anybody has a question, feel free to shoot. All right. We present you your certificate for today's presentation.
Thank you.
Congratulations.
Thank you.
And then this is also just for your visit here altogether.
Thank you very much.
Yes, thank you
very
very much for the presentation and for being here.
Thank you.
All right.
Thank you all. Thank you all.
Thank you guys.